My name is Markus Wagner, and I'm Associate Professor of Law and Director of the Transnational Law and Policy Center at the University of Wollongong. Today's topic is the relationship between national security and international trade, one that has become increasingly uneasy. This issue is primarily dealt with in Article 21 of the GATT and corresponding GATS and TRIPS agreement provisions. Structurally, Article 21 functions as a defense to what would otherwise be a violation of international trade law. This is then very similar to Article 20 of the GATT, which contains the general justifications, but the wording of Article 21 grants WTO members considerably more leeway. How much? That has been the subject of considerable discussions, and panels have weighed in since 2016 in two situations. The Russia traffic and transit dispute between the Ukraine and Russia on the one hand, and the Saudi Arabia protection of intellectual property rights dispute brought by Qatar. Similarly damaging for the international trading system was the erection of protectionist measures ostensibly for national security concerns by the US administration in 2017 through the imposition of tariffs on steel and aluminum. These tariffs were in part directed at countries that were traditional allies of the United States. The question then is, what can states do under this most important set of provisions of Article 21 of the GATT? And here, a WTO member can, number one, refrain from furnishing information where contrary to essential security interests, or B, it can take actions in situations where necessary for the protection of essential security interests. Now, the question then becomes, are WTO members free to do as they please? In the cases mentioned before, some WTO members argue that either panels have no jurisdiction to begin with, or that the language precludes them from making substantive findings. Let me take each of these in turn. Procedurally, can panels undertake a review of governmental measures? That's really at the heart of it. To be clear, this was never ruled out, even at the time of the creation of the GATT in 1947. And this approach, or this finding, was confirmed in the Russia Traffic and Transit Panel decision. And correctly, in my view, the panel viewed Article 21 as a very broad affirmative defense, which, however, does not provide unfettered discretion to WTO members, allowing at least some elements to be open to judicial determination. Which then brings me to the substance. And here I want to focus on some key language that has been found to be objective and thus amenable to judicial scrutiny. First, the existence of a war or other emergency in international relations, which might include the severing, for example, of all diplomatic and economic ties with another member because of alleged support for terrorism. Another sticking point is the language which it considers contrary to or necessary for its national security interests. Such so-called self-judging clauses are not uncommon in international law, but there are limitations. Members can determine what their essential security interests are, but they are subject to meeting a test of good faith, which guards against abuse, very similar to the chapeau of Article 20. To my mind, Article 21 of the GATT is one of the most fascinating provisions of the GATT, and actually of all WTO law. Legally, institutionally, and for reasons of international governance. The notion of national security languished in somewhat of a legal and political no man's land for a long time. The renewed tensions in world politics have, however, made their way into WTO dispute settlement since 2016. When WTO members somewhat gratuitously rely on what was originally described as striking a careful balance requiring good faith in invoking Article 21, they risk undermining the provision itself, but even more importantly, dispute settlement in the WTO and the WTO itself.